staff of parliament, the working decision for the good of 10 million plus people of this country. As Mibla go inshallah this week, you must stop one Mibla, na redeem hard one bla, na the truth must always reveal on the floor of parliament. Na greed by no overtake him, but truth alone, and by saving this beautiful country. Also, me ask him intervention for you, come lo this parliament, lo one individual members, opposition leader, prime minister, speaker, who say participate lo this parliament, lo talk through must always reveal. One of this me ask him only pada, stop na men lo mi pla, na this pray you shall light him lo mi pla. Our Father.
Hallowed be thy name, thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and power and glory, forever and ever. Amen. Clerk, any petitions, notices? Honourable members, question time. The Honourable Member for North Bougainville.
Thank you, Mr. Speaker. Morning, Olga member. Thank you to ask me by directing question me go along Minister of Bougainville Affairs. Me like him to Prime Minister to take note. Minister, new player come up in his Mr. number 2 moon belong this year 2024. Minister, people on Bougainville like Harem. You miss all the me been got talk promise come up na long national government na ABG tokol sem 2023 and by time long ratification belong this 97.7 independence vote by people on Bougainville. Minister, the last year no been got one pla Bungi come up na long 2 very important governments, belong ABG, belong national government. You now long talk clear na updating people on Bougainville. Good Prime Minister belong me, good Prime Minister belong me. One time by me starting back on this talk way been malolo liglik. Me no like talk la why me no come up. Me like cyber this la year. Good Prime Minister, now good Prime Minister belong me. One something by come up like this year long now you me you talk how far have we come? The new player 2024 one something is stop lo people like Harim long. Thank you, Mr. Speaker, thank you Prime Minister, and I thank you Minister of Bougainville Affairs.
The Honourable Minister for Bougainville Affairs.
Thank you, Acting Speaker, for the opportunity to update the National Parliament and the people of this country. I'd like to thank the member for North Bougainville for a very important question asked as to the update on the talks regarding the ratification for the referendum result for the Bougainville. I'd like to inform the Parliament that the issue on the decision to take on the referendum is a very important and serious decision that is facing our country and the government. So this 11th Parliament will be called upon to make a decision to settle the future political status of Bougainville after a ratification procedure is adopted by this Parliament. And on this point, I'd like to say that on the 13th of June 2023, beg your pardon, I have proposed to this Honorable House, in the last statement, ministerial statement I did, proposing the procedure for ratification by way of a sessional order for the members of this Honorable House to deliberate on and to debate. And it is, I believe, is on record, and a draft proposed sessional order has been proposed to this Honorable House. After I proposed the sessional order, a number of issues have been raised by the autonomous Bougainville government in relation to the contents of the sessional order. And therefore, on the 31st of July of last year, a joint supervisory body meeting was called upon to address that. That was held at the APEC House in Port Moresby. And in that JSB meeting, a resolution was reached. And the resolution was that a sessional order would be the procedure by which the ratification is to be had. And secondly, the sessional order is to be adopted by a simple majority vote. And the other resolution was for the two ministers, which is myself and the minister at the ABG, to settle on the contents of the sessional order. And thereafter, the two ministers we have met, and I'm happy to report to the House that on the 20th of January, Minister Marsad and myself have met and resolved on the three specific issues that was raised. The first issue is regarding the two-thirds majority that will be required to decide on the substantive decision on the referendum result. The second is the number of debates, the number of meetings that is to take place for debates, which was to be not less than 2 meetings of the Parliament. And the third issue was the manner of voting, which is whether the voting should go by a secret ballot or open ballot. And I'm happy to report that the two ministers have resolved the two issues. That is on the meetings, the debates of meetings, and the manner of voting. We have resolved that the debates should progress, debates and the manner of voting should progress according to the normal practices of Parliament, which the chair will administer. But we were not able to resolve on the issue on the two-thirds majority for the substantive decision. So on the 8th of February, we met again, and we have allowed for the legal team from both the ABG and the state solicitor, the lawyers from the Office of the Minister for Justice and Attorney General, to actually settle. Our position was that the substantive decision has to be made on the referendum result by a two-thirds majority vote. The reason simply being that it is the state solicitor's advice on the government. And the other reason basically is that when the referendum was held for Bougainville,
Honourable Minister, we have a point of order. The Honourable...
The member asked a very simple question, and that question is, when is this going to happen?
Yes, yes.
We don't need a big lecture, we just need a response. Thank you.
Honourable Governor will take note of your point of order. I'll ask the Minister to finish.
Thank you. Thank you, Honourable Governor, for issuing for the point of order. I think the matter is a little bit complex and serious for this Honourable House to really seriously ponder and deliberate on it before we make a decision for the people of Bougainville and this country. So I was trying to explain, this is part of the awareness for the House, for us to actually grasp the gravity of the issue that is at hand. So I was trying to explain that the only issue we have is the two-thirds majority vote that is required. That's the issue we have at the moment. And the lawyers are trying to resolve that. But the reason put forward was that the referendum was only allowed for the Bougainvillians to be had, which is according to Part 14 of the Constitution, as allowed by or sanctioned by the Constitution, as well as the Bougainville Peace Agreement. But unfortunately, the rest of the country was not allowed to be to have a referendum, to have a say on the political future of Bougainville. Because of that, we were of the view that the representative of the people of Papua New Guinea are all seated here. You are the representatives. We thought that the 118 members of the parliament would have a say on the results of the referendum. However, the Constitution does not prescribe or provide such a thing. So from the advice of the state solicitor, we would settle on the minimum requirement, which is 2/3 majority. The ABG's position is that that it should not be 2/3 majority, but it should be a simple majority. You see, so that is the issue. So I will actually make a statement and bring forward the update and propose the revised and the final sessional order, and it is up to this parliament to deliberate, debate, and adopt which is the appropriate majority to take that decision. So as soon as the two ministers meet again to resolve on the 2/3 regard majority, we will have another joint supervisory body meeting to endorse that issue, once that is agreed upon by the two ministers and the technical team. After the JSB, we will flag it across the NEC for endorsement, and then I'll have it proposed in this House in my next assessment. And we hope that this 11th Parliament should take a decision on the referendum in this year. Once the Parliament adopts the sessional order will be in effect until it will be in effect for the session of the 11th Parliament, until the 11th Parliament the session of the 11th Parliament is terminated or discontinued by a dissolution of Parliament, or maybe a prorogation of Parliament, or by fraction of time, which is when the Parliament rises to go for the next general election. Thank you, Mr. Speaker.
We have a supplementary. The Honourable Member for Abao.
Thank you, Acting Speaker. My supplementary is one. Can the Minister agree or deny that the promise that the government made to sort this issue of sessional order in 2023, that the government failed the people of Bougainville? Can you deny or admit that? Because I understand that that was a commitment made. Number two, Mr. Acting Speaker, the Minister for North Bougainville, member for North Bougainville, asked for what is the government program for 2024 in order to address this issue. You haven't answered that question.
The Honourable Minister of Bougainville.
Thank you, Mr. Speaker. I thank the good member for Abao for raising that supplementary question. I would think that I've answered substantively the supplementary question, but for the benefit of the member who asked, let me say that in regards to the sessional order to have been adopted and a decision for the ratification to have been made in last year, I'll have to say that under the Erakona agreement, it was agreed that the ratification for the referendum result is supposed to be done in last year. But the problem was, as I have raised in my previous statement, Section 342 of the Constitution and Section 311 of the Bougainville Peace Agreement does not specify a procedure for ratification for the Parliament to deliberate on, debate, and follow to make a decision on the referendum result. That is the reason why I have proposed in my last statement, 13 June, for Parliament to adopt a sessional order. So that procedure for ratification has to be put in place before this Parliament makes a decision. That is why the Parliament could not be able to make a decision or ratify the referendum result last year. To answer the second supplementary question, I think the program for this year for the government regarding the Bougainville referendum is for the government to put before this Parliament to adopt a sessional order that I'm talking about. It is the ratification procedure. That is the only issue we have to conclude the long-standing Bougainville peace process. After the ministers have met and resolved on the 2/3 majority required vote, we will flag it before the next joint supervisory body meeting, and then it will come before the NEC for endorsement, and it will come before the Parliament for Parliament to endorse. That is what we are going to be doing this year.
Honourable Minister, we have a point of order. Honourable Member for Abao.
With the greatest respect to the Honourable Minister, is really focusing purely on the legal component process of the ratification process. But whole of this year, 2024, there are other provisions like consultations. Those programs need to be displayed. You must announce. What are we going to do? You're just talking about a parliamentary process called sessional order, and your government has not sorted it out, but there are other provisions. The Constitution strictly recommends a consultation process. And apart from the two government consulting, the information education for the members of parliament, they have not been processed.
Honourable Member for Abao.
That's what I'm asking for. 2020, this year, what are you going to do?
Honourable Member for Abao, I take note of your point of order, but I've seen you trying to make a statement into what the Minister is saying. Minister, this is question time, and we have taken much time on this question. I'd ask you to get to the point and allow for the question time to continue. Thank you, Minister.
I think the good member is repeating the same question. I think what we are doing these days, it's the consultation that is still ongoing. So ratification is what is required for this Parliament and the government to do at this moment. So that is what we are doing. So the meetings and everything else is part of the consultation that is required in the Constitution and the Bougainville Peace Agreement. There's nothing else to do. The only thing that is left for this Parliament to do is to ratify the referendum result. Thank you.
The Honourable Governor for Morobe.
Mr. Speaker, I rise at this point in time to ask the question not on notice to the Honourable Minister for Health. And I understand also that he is also a minister responsible for agriculture and quarantine inspection. And I invite the Minister for PNG Customs and PNG Ports, I don't know who that minister is, to take note of the series of questions that I'm going to ask. Mr. Speaker, before I raise those questions, I will give you the circumstances which leads to these questions. Mr. Speaker, today I inform members of the Honourable Members of Parliament that Papua New Guinea is currently eating certain illegal rice products which do not meet PNG food safety standard as required under Food Sanitation Act of 1991 and its regulation of 2007. Mr. Speaker, I'm flabbergasted to learn that this rice was imported and sold by a foreign company to Papua New Guinea citizens without meeting the Papua New Guinea laws that I have mentioned above. Furthermore, Mr. Speaker, members of the Parliament, it is heartening to learn that 2 government department officials were facilitating these illegal rice imports without following the following the established procedure for approval. Mr. Speaker, I have been reliably informed that a foreign company imported certain illegal rice into the country without required health compliance certificate. The certificate is normally issued, Mr. Speaker, by the Food Sanitation Council under the National Department of Health. The company has so far imported a total of 200 kilograms of rice, this rice, illegal rice, and supplied illegally to the consumption of Papua New Guinea, including members of Parliament. You may have eaten. Mr. Speaker, as a political leader of Morobe Province, and as Prime Minister already said, and I concur always with his opinion, that we are in excess of million population. And secondly, we host 2 rice factories in this country, Trukai Rice and the Homestead Corporation Limited Rice Company, supplying rice. Mr. Speaker, I am concerned because rice being a major staple food for many Papua New Guinean families, they eat rice every day. Therefore, those state entities must fully have a responsibility to comply with the law to make sure the rice imported into this country and supplied to the citizens for their consumption must comply with the laws of this land. Mr. Speaker, I have supplied the question that I'm going to ask to the Honourable Minister. So he has fully, I'm sure, read the statement and the questions, and I'm sure, I'm confident today he's going to answer those questions. Mr. Speaker, the series of questions I'm going to put to him are as follows. Question number 1, Mr. Speaker. Minister, are you aware that officers within the Department of Health are facilitating this illegal rice to enter Papua New Guinea and to the left to the consumption of Papua New Guinea citizens? Number 2 question. Minister, this practice by a foreign company shows its lack of respect for Papua New Guinea laws. Minister, what is your department going to do to ensure that this company complies with the Papua New Guinea laws, relevant laws I have cited to you? Number 3, Mr. Speaker, public servants are corroborating with the company in violating Papua New Guinea laws. We look up to the public servants to implement and enforce our laws, policies and rights standards, so people are protected, naturally protected. Mr. Minister, what are you going to do with these public servants if you find out that they have actually breached these particular Papua New Guinea laws? What are you going to do? And finally, what is your department or our department going to do in terms of illegal rice products currently in circulation in this country? Mr. Speaker, those are my questions to the Honourable Minister for Health.
The Honourable Minister for Health.
Mr. Speaker, I'd like to take this opportunity to thank the good governor of Morobe for these very important questions I raised this morning. But before I do so, I also want to take this opportunity to thank the good Prime Minister for giving us this opportunity to represent the government as the Health Minister. Mr. Speaker, rice and other products that are actually exported to this country are actually being monitored by the government through a strict compliance regime. What that means is that things like rice, when they before being imported to this country, need to make sure that they meet certain standards, and that those standards, once they are met, a health compliance certificate is then issued. In terms of rice, it goes through a process called a rice fortification process. What that means is that rice in its natural form comes with some trace vitamins, some trace elements that are quite necessary for the human body. But when it goes through the processing, it loses some of those vitamins. So what that means is that before any factory overseas exports rice to our country, they have to add those vitamins back. And that process is actually measured. And after measuring that process, there are laboratories that they subject those rice specimens to. And once that's done, when they find adequate levels of those trace vitamins, usually some vitamins that are quite essential for our body, vitamin B1 and B2, and even iron for that matter. Once they measure those rice samples to see whether those meet the required standard, the required levels, health certificates, compliance certificates are given. Now, in this case raised by the good governor of Morobe, there was a company that was importing rice to PNG. Now, I'm fully aware of this issue because the Ombudsman Commission has also written to my office. And we're looking into that matter. So what happened was that when the company actually imported rice to PNG, their compliance team got some samples. And when those rice are being imported to our country, a couple of things needs to happen. They have to have the certificate of analysis, which prescribes the levels of those vitamins, the trace vitamins that I've mentioned. And they also have to have a certificate of health compliance. And that certificate of health compliance is basically our inspectors going, or the inspectors prescribed by some international bodies, going to that factory to make sure that they meet the minimum requirements that are needed. In this case, what purportedly happened was that when the rice came to our country, it came with the other certificate, the certificate of analysis, but the certificate of health compliance was not there. So what Health Department decided to do was to send some samples to Australia. But when the samples were sent down to Australia, there was another independent team that went and did an assessment on the facilities in Taiwan. Rice is originally from Thailand, but it's actually exported to Taiwan where the packaging happens. And when the team went, they realized that there was a lot of compliance issues. But when the sample results from Australia came, they realized that the vitamin levels and the iron levels were within the minimum requirements that that the country needs. So basically, a certificate of compliance was issued based on that result from Australia. And so the rice containers were cleared and being sold. But whilst they were being sold, the compliance team decided to check again, and when they checked, they realized that they had some issues in the processing facility, issues of compliance. So I think last year, the health secretary wrote to them stating that we would stop the sale of that rice whilst we get further clarification and further from our team. So basically, my good governor, Speaker, this case is actually before the Health, Sanitation and Food Sanitation and Regulations. They never complied with the Food Sanitation and Regulations Act. So what basically we are doing right now is that we will be issuing a statement on the media. But before we do that, the council has to meet and give us their direction. The health department cannot act on its own. It has to go through the Food Sanitation Council, and that council has to issue us, like an order, for us to go to media to basically say that this rice is currently illegal. What has transpired so far is legal, and we want to follow the process established by our own laws. So basically we're coming to the end of it, and we will be getting a report from that council soon, and when the report comes out, the health department will then go out to the media and publish, based on that report, whether that rice should be legally sold in this country or, according to our standards, should be deemed illegal. Thank you, Mr. Speaker.
We have a supplementary.
Speaker, to the Minister again. What measures will the department take to ensure that this does not happen again? I mean, in this instance, the rice should never have been allowed into the consumer market. The testing process should have been completed before the rice was allowed into the consumer market. So can the Minister explain if the department is going to ensure that this does not happen again by putting in the relevant control measures in place, so that the testing is done before the rice is released into the market on all imports of rice?
The Honourable Minister for Health.
Thank you very much. Let me thank the good governor for that supplementary question. Basically, we subscribe to international standards. So the companies who are actually sending rice here have actually gone through the process. That process has actually cleared them. But we've received some complaints, so we decided to do our own independent checks into the quality of the rice, and we send those samples down to Australia, which came back stating that the samples were okay. But then production of rice needs to happen in a facility that meets those standards. And unfortunately, we can't travel to all the country to check their facilities. We depend on internationally sanctioned organizations to do that. And unfortunately, that organization in Thailand failed its part, Governor. So that's where we are. But on our part, you know, in terms of international trade, because of globalization, we depend on each other. And that organization, that international organization, unfortunately failed because obviously business interest and some other companies who had business in supplying rice decided to go and do their own due diligence, and they checked and they realized that there's some critical things that were not right and that needed to be reviewed. So we then asked that independent team to check, and the results have come back. So like I said, international testing standards that meet ISO standards, they do their testing there, and when they approve, it comes to our shore. And we've done our due diligence. That's why, because of the due diligence we did by sending samples again for an independent assessment, we found that the rice, though it met standards, the facility under the conditions under which the rice was being produced has a lot to be asked. So those things are actually being looked at by the department right now. So to cut the long story short, let me say we have a good team there here in country which are actually doing their jobs. If they had not done their jobs, we wouldn't have the second verification report that we received. Thank you.
The Honourable Member for Vanimo Green.
Thank you, Mr. Speaker. Mr. Acting Speaker, before me ask him a question without notice, you threaten this something here, me tu lo this side must look in time. How much time am stop here? How much time you can look him lo time lo debate now this something. Please, Mr. Acting Speaker, you must threaten so this side lo this laos must look him. Thank you, Mr. Acting Speaker. Question blow me without notice, and we go to Prime Minister. Mr. Speaker, for last week Sunday, time government and me carry him first motion, lo come pass him law, lo declare him Papua New Guinea or some Christian country on the eve of the first motion and the first reading. And on the 18th, which was on Sunday, 2 days ago, while the Prime Minister was busy worrying about these political numbers in recruiting the governor for Milne Bay,
Honorable Minister, what's your point of order?
Speaker, please enough, leader ask him question and not going to deviate. What is mentioning is not part of his question, I believe so. He should stick to his question, Mr. Speaker.
Honorable Member, Minister, your point of order is in order. Honorable Member for Vanimo Green, whatever prerogative its Member of Parliament took, it's their prerogative and it's not good using it into address of any question you raise. So, Honorable, I allow you to continue your question.
Thank you, Mr. Acting Speaker. My point is that while all these things were happening, there was a mass massacre of more than 64 people in Sikin and Kaikin tribes in Wapanamanda, Hanga province. And Mr. Acting Speaker, let me just take us back to and refresh our minds of another massacre that happened in July 2019, just 6 weeks after the Prime Minister got elected as the Prime Minister. In Munima Karira village in Tagali LLG in Taripori district in Ela province. In that massacre, Mr. Acting Speaker, more than 24 people, innocent men, women, and children, were massacred. That massacre was strongly condemned by the United Nations on the 19th of July, 2019. And Prime Minister himself also sent a very strong warning, and I quote, "I am coming for you." Mr. Speaker, since then, there has been mass killings, senseless killings in Enga and Ela provinces, and also in some parts of our country. And from what I can recall, I have not heard any reports in this Parliament as to what the government has done to those murderers or so-called warlords. Mr. Speaker, the massacre on Sunday, the 18th of this month, just 2 days ago, is another dark moment in our nation's history. Mr. Speaker, from my expert view as a former military officer, that particular massacre is seen to be a well-planned operation. Whether it was an ambush, where the enemy tribes were lying in wait, or it was a full-on assault with high-powered military weapons. Mr. Speaker, my questions to the Prime Minister are as follows. Number one, Mr. Speaker, what is your government's policy on combating law and order situations and the tribal warfares which are spiraling out of control in our country? Number two, can the Prime Minister inform this Parliament and the people of our country what his government has done so far in combating the law and order situation and tribal warfare in our country? Number three, can the Prime Minister inform this House and the people of our country how many of those murderers and so-called tribal warlords have been arrested and brought to justice? And if not, then why not? Number four, Mr. Speaker, can the Prime Minister also inform the Parliament and the people of this country what level of combat readiness is our military? I say our military because our military has been constantly been deployed in the state of emergencies up in the highlands of Papua New Guinea. What is the combat readiness of our military? Number five, what is the force readiness of our police force to combat law and order situation in our country that is escalating almost daily, every day? What is the force readiness? Number six, what is the operational readiness of both disciplinary forces? Number seven, what is the level of the morale of the disciplinary forces? If our disciplinary forces, their morale and the discipline is down, Mr. Speaker, it will be very difficult for them to be deployed and for them to effectively discharge their operational duties. What is the morale and discipline level of our soldiers, our policemen, our CIS personnel in our country? That sort of assessment, Mr. Acting Speaker, must be done so you know the level of readiness of your three disciplinary forces. Number eight, Mr. Acting Speaker, what level of resources and manpower has the government expended and deployed throughout the country in the SOEs? And I want the Prime Minister to provide this House with facts and figures. What are the government's plans and strategies to stop this nonsense? We have declared ourselves as a Christian country. And we are heading towards becoming the richest black Christian country on planet Earth. And yet, in the last 5 years, our law and order situation, instead of a country that is not supposed to be a Christian country. Can the Prime Minister inform the nation as to his plans and strategies to stop these mass murderers, tribal warlords, and people who are trading illegal arms in the country? How is he going to address this issue? I have on many occasions, Mr. Speaker, called on the government to table the single guns report on this floor of Parliament and have it debated and have its recommendations implemented. And nothing has been done to date. Mr. Speaker, does the Prime Minister and his government have an intelligence network that is readily available to be able to trace who is trading the guns, where the ammunitions have been brought in from? And it's a small country. We can have this information in our fingertips. What has happened to the intelligence organization in the military in the police force and in the National Intelligence Organization. What are his plans to strengthening the intelligence agency and the intelligence apparatus in the country? Mr. Speaker, earlier in 2022, when I was appointed the chairman of Permanent Parliamentary Committee Chairman on Foreign Affairs, Defense, International Trade and Immigrations, I made certain proposals to the Prime Minister. My proposal to the Prime Minister to deal with law and order situation in the country and with the tribal warfare in the country was to establish a Ministry of PNG Homeland Security and Department of PNG Homeland Security. The proposal basically was for this particular ministry to deal with law and order situation in our country. And Mr. Speaker, my question to the Prime Minister is that, can the Prime Minister take my proposal into serious consideration, decommission one of those ministries who have no utility, and establish a Ministry of Homeland Security and Department of Homeland Security, where you have the top-notch soldiers, the policemen, the immigrations, NIO, and all these security apparatus put into this particular ministry and the department to deal with law and order situation, and let's deal with it once and for all. Mr. Speaker, why don't we adopt or we establish this ministry, take advantage of our defense cooperation agreement with the U.S. and implement the policies that we want to deal with the law and order situation. Mr. Speaker, my concerns are that if we do not deal with the...
Honorable Member for Vanimo Green, we have only 3 minutes left for the question time to be led, so I would like you to sum up your question and let the Prime Minister to respond before.
For Parliament to extend question time.
Yes, second it.
Honorable members, the question is that the question time be extended in 20 minutes. Those in favor, stand. Honorable members, we do not have the support in extension of the question time. Honorable Member for Vanimo Green, I'd ask you to sum up your question.
Thank you, Mr. Speaker. My final question, Mr. Speaker, what plans does the Prime Minister and his government have to put a stop for these murderers and tribal warlords from infiltrating into other peaceful towns and cities of our country? With this Connect PNG, these people will be leaving their homes and running for safety to peaceful towns and cities with their culture. And they will go and destroy these other towns and cities, and it has already happened in Western Province. Mr. Acting Speaker, what are the Prime Minister's plans, the overarching security plan on dealing with law and order situation and the tribal warfare in our country? Thank you, Mr. Acting Speaker.
The Honorable Prime Minister.
Mr. Acting Speaker, me like talk big, but thank you, Lord. Member of Vanimo Green, let me ask him a very important question that concerns all of us. I want to appreciate this question. Mr. Acting Speaker, me like talk of them. It pains all of us, me especially as face of your country, or our country. You know, when we get these sort of reports where lives have been lost, let alone 50+ lives, it is not a joy and joyful news. It continues to pain us and bleed us with this sort of news that we have deaths happening as a result of others killing others. And I want to sincerely, firstly and foremostly,
pass my condolences to the family of those who are currently bereaving the loss of those children, those youths. When we saw the pictures, it was mostly youths who were engaged in those exchanges that saw their lives being lost. But I want to say that the question is a serious question. The member for Bougainville Green has asked, in the last I counted, I think up to 9 questions. If the leader could be kind enough to furnish to me detail of all these questions today, I will get a very detailed response on what we are doing as a government, because we saw again on the January 10th where lawlessness was abound. We saw here lawlessness is abound. I want to assure this House, it is not as if we have not been doing anything. Just to give you all some snapshot, since 1975, we have been changing police commissioners as if we've been changing our underwears up till this point in time. No police commissioners have had long-term tenureship in office. I give you one period in our recent past. From 2011 to 2018, we've had 4 police commissioners. Commissioner Wakambi, Commissioner Kulunga, Commissioner Vaki, Commissioner Baki. 4 police commissioners in 8 years. You don't expect discipline, enforcement, structure, efficiency in a very key constitutional office when heads of this important constitutional institution that is supposed to safeguard our country. So erosion has taken place in our police force over many, many years, but I take full responsibility as head of this government, going now almost into 5 years. And the country deserves to know exactly what we are up to. The signing of the bilateral security agreement with Australia, the signing of the defense cooperation with USA is all in the interest of ramping up capacity and interventions in our security apparatus in our country. As well as this one, our own government in the last 3 years have consistently ramped up budgetary support like never before. I give you one sector of the law and justice sector. The ministerial services before 2022 have been receiving under 8 million kina a year for its recurrent expenditures. Now, why do I bring in ministerial services into the discussion on police matters? Where do you process? The answer is simple, Mr. Acting Speaker. Where do you process those who are arrested or supposed to be arrested? You process them into the ministerial services, and later you funnel them upwards for serious crimes into the higher courts. And so we've taken a holistic look into the entire law and justice sector allocation. Our own government has ramped up allocation to the sector. Police has received today, second year on, back-to-back 2023 and 2024. You parcel these 2 financial years together, that's over 400 million kina would have been allocated to police. Never before in our nation's history these sort of operational resources being allocated to police. All because we know that number 1 threat facing us is lawlessness. The economic growth and everything else that's happening will be totally redundant without securing the security of our country. And so, excuse me, Mr. Acting Speaker, I want to give respect to the good question asked by the member for Bougainville Green. Whilst for politics, he may have a political undertone, but let's remove that political undertone. His question is a correct series of questions. He's asked an important question for our nation. It deserves a fair answer and a correct answer. And we, as head of this government, with the assistance of Deputy Prime Minister, who has a handle on the law and justice sector and has been doing a wonderful job in this space, and our police minister, we will construct a reply. And if I could preserve our first right of reply tomorrow morning to answer these questions, that is in our national interest. But in the meantime, I just for the event or the atrocity that has happened rather in Wabek, we classify them as domestic terrorism. And I want to encourage our youth up there. At no time must you encroach into another tribal land. Why do you encroach into another tribal land? First and foremost, Our people must take serious responsibility upon themselves. I would repeat this statement many times. The easiest and the best contribution our people can do to this country, which is absolutely free, is respect to the rule of law. And we have been working in this matter in Enga province, as well as Hela and others, for the inference or reference to the matter that took place in Karida electorate, in my Karida village in my electorate. I want to inform this House, certain arrests have been made, certain community arrests has been made, certain people who perpetuate this have found their way into the grave by their own doings. I want to commend a local councillor in that area, Councillor Oli. He needs to be mentioned in this floor. Councillor Oli said not to fight. And 3 years on, he's maintained this stand. This sort of leadership is required of all community leaders right across the length and breadth of our country. In my own electorate, one council president is behind bars today for being set upon in his house, where ammunitions were found in his house. So, Mr. Speaker, I want to indicate to this House that we work to the best of ability, but in the current deficiency of the entire police structure, we're trying our absolute best to arrest. And tomorrow I will give an indication as to where we are, including the ramp-up of police training that is taking place right now, with the special focus on special elite police force that is trained to handle domestic terrorism. These matters happening in Enga province and elsewhere, we classify as domestic terrorism. We're also restoring police leadership in Enga province and the Western Command with new leadership. There is a proposal for us, and the police commissioner has been on the lookout on the market for a special police officer to be deployed into Enga province with local knowledge as well as expertise at a senior level. That has been looked upon to stabilize Enga in a new way. I want to give an assurance to this House that tomorrow, when I respond to all the good questions the leader for Wainumu Green has asked, I think that could bring further clarity on what we are doing. But full assurance to this House on both sides and to our country, to our investors, that law and order remains our #1 focus. The reason of us appointing Commissioner Manning back-to-back is to establish for the first time one commissioner for possibly 8 years, so that stability could cascade down into the structure. Under his words, over 300 police have been disciplined to date. They have been removed from the force for ill discipline. That sort of removal from force has never taken place before. That's because someone has continued into...
Honorable Prime Minister, we have a point of order. Opposition Leader.
Mr. Speaker, I think the Prime Minister has already made it very clear that tomorrow he will give a proper response. And seated here, I'm yet to hear an answer to all of the 9 questions that have been asked. So since the Prime Minister has already said that, give an assurance that tomorrow he will give his answer, I think we should leave it there instead of lecturing this room. Thank you.
Honorable Opposition Leader, your point of order is out of order. I think the Prime Minister have made it clear, and he's about to sum up his question, so I'll ask him to...
All right, thank you, Mr. Acting Speaker. You know, it demands all of us to be aware on these matters and raise concern. I appreciate the opposition leader. In his own electorate, he lost 32 people dying as a result of Bushnight lesson right after the elections. In a place like Millen Bay, we had issues with lawlessness. A place like Kokopo, it's emerging. And I don't sleep well at night knowing that good places like Millen Bay and Kokopo, we see these bubbles taking place, and we are very serious about this matter too. So we appreciate the opposite for concern on this one. It's a shared concern, it's a bipartisan concern. Tomorrow I will respond to the 8 or 9 questions that the leader for Wainumu Green has made response, but be rest assured, Police Minister and all of us are working to attend to this at the very earliest, short-term, mid-term, and long-term solutions. Thank you, Mr. Speaker.
Leader of Government Business.
Mr. Acting Speaker, ask leave of Parliament to move a motion without notice.
Leave granted. Make a motion.
Mr. Speaker, I move that so much of the standing orders be suspended as would prevent notice number 84, 85, 88 and 89 government business being called forthwith.
The question is that the motion be agreed to. Those in favor say aye. Those against say no. Ayes have it. Clerk.
Notice number 84, Minister for Justice and Attorney General.
The Honourable Minister for Justice and Attorney General.
Thank you. Mr. Speaker, I present the Arbitration Domestic Bill 2023.
Clerk.
First reading, a bill for an act to A, recognize and give effect to the agreement of contracting parties in domestic commercial agreements and other domestic agreements or any other domestic matters amendable for resolution by arbitration. B, to repeal and replace the Arbitration Act, Chapter 46, with respect to domestic arbitration. C, to promote use of modern forms of arbitration as a means of alternate dispute resolution and for related purposes.
Minister for Justice and Attorney General.
Mr. Acting Speaker, I move that the bill be now read a second time.
Make your speech, Minister.
Thank you. Mr. Speaker and members of this Honorable House, it gives me a great pleasure to introduce the Arbitration Domestic Bill 2023. The bill repeals and replaces the Arbitration Act 1951. Mr. Speaker, Papua New Guinea acceded to the Convention on Recognition and Enforcement of Foreign Arbitral Awards, New York Convention, in 2019, which now enables PNG to demonstrate or domesticate the arbitration rules of the United Nations Commissioner on International Trade Law. Mr. Speaker, arbitration is a dispute settlement mechanism that is a complete alternative to ordinary litigation. It is both consensual and private in nature and operation, resting largely on party autonomy, whereby parties can enjoy a very substantial amount of freedom in laying down the preferred rules to resolve an arbitral dispute. This freedom is guaranteed to physical and legal persons by formal law and the national legal system. It is in that respect that, despite its private nature, arbitration operates more meaningfully through state sanction enforcement.
whereby national courts are prepared to enforce arbitration agreements and to lend their assistance in enforcing awards that are not complied with voluntarily. Courts and domestic law must also be prepared to assist where party autonomy proves insufficient, such as when the process of appointing arbitrators breaks down. Arbitration must therefore always take into account the existence of national legal systems and the limits or interference that may derive from them. Existing legal framework. Mr. Speaker, the law governing arbitration in PNG is the Arbitration Act 1951. This pre-independence law in its current form is not conducive and compatible to cater to both domestic and international arbitration in PNG. It is not consistent with international best practices which have developed through international instruments such as New York Convention and Universal Model Law, which has come to be adopted by many jurisdictions. Mr. Speaker, having acceded to the New York Convention in 2019, it is only appropriate for PNG to now reform its existing law to provide an up-to-date framework for both domestic and international arbitration. A dual-list approach is taken on PNG's reformed legal framework, which sees two separate laws. There will be an arbitration bill which will deal with domestic arbitration, whilst the arbitration international shall be dealt specifically with international commercial arbitration. The purpose of arbitration and Domestic Bill 2023. Mr. Speaker, the purpose of the bill is to, 1, make provision for the commencement and the conduct of domestic arbitration. 2, provide a framework for the enforcement of arbitral awards. And 3, to repeal and replace the Arbitration Act 1951. Scope of arbitration, Domestic Bill 2023. Mr. Speaker, the scope of the proposed arbitration Domestic Bill 2023 is intended to cover domestic arbitration that takes its place in PNG as opposed to international arbitration. Domestic arbitration involves where the subject matter of the contract is in PNG. The merits of the dispute are governed by PNG law, or where the procedure of arbitration is also governed by PNG law. The intention is to provide a framework in which procedural rules chosen by parties to govern the arbitration can operate and may fill gaps not addressed in the rules. Features of the Arbitration Domestic Bill 2023. Mr. Speaker, the following are the prominent features of the bill. 1,
emphasize the importance of the arbitration agreement by laying down the formal requirements for the agreement, particularly that it may be in written form. 2, establish matters that are arbitrable. 3, establish procedural rules for the commencement and the conduct of arbitral proceedings, including court referrals to arbitration. These rules include principles of fairness and equal treatment of parties, hearings and written proceedings, representation, and expert involvement. 4, establish rules on the arbitral tribunal, including the number of arbitrators, grounds and procedure for challenging the appointment of an arbitrator, and liability and immunity of arbitrators. 5, establish the competence of the arbitral tribunal and its powers relating to interim measures and preliminary orders. 6, establish rules on an arbitral award, including the power of the courts in relation to an award, and 7, establish court powers exercisable in support of arbitral proceedings, particularly where parties seek interim injunction or other interim measures. Mr. Speaker, finally, I would like to acknowledge the judiciary for the recognizing and the significance of this important reform and leading the work for the development of this bill, together with the Arbitration International Bill 2023. I would like to also acknowledge the contribution of all who have assisted with the accession process to the New York Convention and the drafting of the bills. I thank you all for the effort put into come this far. With that, Mr. Speaker, I now commend the Arbitration Domestic Bill 2023 to this Honorable House. Thank you.
The Honorable Governor from Morobe.
Thank you, Mr. Speaker. I rise to support the bill sponsored by the Minister for Justice and the Attorney General of this country on the law of arbitration in this country. I want to put it very clear that this country is an independent country. It is not a colony of other country. This is an independent country. And the law which was passed in relation to arbitration was in 1951, when we were a colony of Australia. And they were designed to make sure that whatever dispute in Papua New Guinea in relation to any contracts entered into Papua New Guinea, and Mr. Speaker, in the event that there is a dispute between the parties to the contract, they made it in such a way that it opened up for the matters to be arbitrated by arbiters of a foreign country. For instance, for example, any disputes not agreed by the parties and taken to court, and the court, in its wisdom, applying the rules of law, decides that this matter should be arbitrated. By the arbitrators, they recommend that this arbitrator, a foreign arbitrator, to arbitrate on the matters in disagreement. Mr. Acting Speaker, I thank the Minister, in your wisdom, by doing the right thing, to introduce amendment to Arbitration Act of 1951, so that in this country, and if the contract is in relation to matters in this country, and there is a breach of contract by whichever parties that concerns them, they will use Papua New Guinea laws to arbitrate. And as I said, Mr. Acting Speaker, when the matter goes to the national court, or whatever court in PNG, and if the matter rightly, the court rightly considers that this matter be dealt with through the arbitration, then it must be dealt with by arbitrators appointed to deal with those matters, and the arbitrators which live in this country, Papua New Guinea. So the bill intends to make that thing happen. And we Papua New Guineans, with all due respect to us all, is that we don't have the luxury of plenty of money. We don't have the luxury of plenty of money. And there is disputes that need to go to national court or whichever court and referred for arbitration. And if this law, Arbitration Act of 1951, continue to exist, then we are required to employ the arbiters from outside to come and arbitrate. And that's a very expensive exercise. And Mr. Acting Speaker, there's so many disputes which the National Court and other courts refer for arbitration has not been arbitrated. Because the law, Arbitration Act of 1951, says to get an arbiter from outside. And Mr. Acting Speaker, they're waiting away. And many of the claimants have died through no fault of themselves, waiting for the dispute to be settled by the arbiter as ordered by the national court or whichever court. And it's very expensive, as I said from the outset, Mr. Acting Speaker. And Papua New Guinea, who has very little money, he's got a cause of action. He's got a cause of action for the breach of contract. He's taken to the national court, he's got a small money. And that claim may be valued at 1 million or 2 million, whatever that might be. But when been taken to the national court saw fit to say this matter should be dealt with by arbitration and refers it. And then arbiters from overseas, Mr. Acting Speaker. And it's going to cost him a lot of money, him or her, a lot of money to, Mr. Acting Speaker, to get his matter arbitrated and eventually recommends to the national court to agree on the decision of the arbiter. Either one arbiter or 2 or 3 arbiter. Depends on the order of the national court or whatever court that may be. And so, Mr. Acting Speaker, the Attorney General's bill is right on time, is fitting at this point in time in the history of this country. We changed the law. So any contract, any dispute in relation to any contract, Mr. Acting Speaker, done in this country, and the national court or whichever court refers for arbitration, then should be arbitrated by arbiters who live in this country, Papua New Guinea. And as the Minister said, The aim is to make sure that there is a fair dealing of whatever matters that have been referred. And we can trust the arbiters, Mr. Acting Speaker. Trust the arbiters, our own arbiters. They understand us. Papua New Guineans, we understand each other, right? It may be custom influence. It may be whatever influence which led to the breach of the contract or whatever that may be. So, Mr. Speaker, Mr. Acting Speaker, the bill must be supported, And secondly, in relation to international contract between a country and a country, of course, applying the international law, then of course we can get the international people to arbitrate on those kind of contracts, Mr. Acting Speaker. And those are very few, Mr. Acting Speaker, very few contracts like that. Otherwise, the majority of the contract in relation to work done in this country, majority of the cases in this country are in relation to matters which occurred in this country. And therefore, our rule of law, Papua New Guinea law must apply. Not international law must apply, but as it relevant to the matter, the agreement, Mr. Acting Speaker, Papua New Guinea laws must apply. Papua New Guinea Constitution must apply, or Papua New Guinea contractual law, or whatever law that may be appropriate for the circumstances of the case, which had been referred for arbitration. Papua New Guinea laws must apply. And for a long time, many cases have been referred for arbitration, have not been dealt with in a satisfactory, in a prompt time, and many of the parties in the cases have died, leaving behind their rights not well enforced. Therefore, I rise to support and unreservedly support the Honourable Minister, Minister for Justice and the Attorney General, that the bill is salient, and the government, and even in the opposition, you might not know, one day it might help you, this law. When you are a parliament member, or even you are still not a parliament member, but as it applies to you, and as the court directs, Mr. Acting Speaker, it will become relevant to you. And therefore, I urge the opposition and the government to, without reservations, support and give pride to the nation, the sovereignty. Our country gain independent, and we must use our laws to apply to the circumstances which are more appropriate to us. Mr. Acting Speaker, thank you for allowing me.
The Honourable Member for Sinasina Yangon.
Mr. Acting Speaker, the reform suggested by the Attorney General here will provide a very important platform for the future of business and commerce, both domestically and internationally going forward into the future. Therefore, all of us here in opposition, we support and commend the Attorney General for bringing this bill to the floor of this Parliament. And I therefore, Mr. Acting Speaker, move that the question be put.
The question is that the question be put. Those in favour say aye. Aye. Those against say no. Ayes have it. The question is that the motion be read the second time. The bill be now read the second time. Those in favour say aye. Aye. Those against say no. Ayes have it. Clerk.
Second reading. A bill for an act to recognize and give effect to agreement of contracting parties in domestic commercial agreements and other domestic agreements or any other domestic matters amendable for resolution by arbitration, B, to repeal and replace the Arbitration Act, Chapter 46, with respect to domestic arbitration, and C, to promote use of modern forms of arbitration as a means of alternate dispute resolution and for related purposes.
Minister for Justice and Attorney General.
Thank you, Mr. Speaker. I ask leave of Parliament to move the third reading forthwith.
Is the leave granted? Minister for Justice and Attorney General.
Mr. Acting Speaker, I move that the bill be now read a third time.
The question, the Honorable Prime Minister.
Mr. Acting Speaker, let me rise to give support to this timely bill that the Minister for Justice and Attorney General is bringing in. The Arbitration Domestic Bill of 2023 modernizes our country and gives support to our judiciary. We were operating under the 1951 Act, Arbitration Act. I want to say, and I commend the opposition spokesman on this matter, who have given support, and the opposition who stood in support of this bill. Mr. Acting Speaker, this gives assurance to not just ourselves in our economy, but more importantly, the major investors and all investors we have coming into our country. This should be pronounced to everyone. I mean, like, give him, look how long, all investors who set up inside our country, believe me too. This is an alternate form of dispute resolution. Arbitration is now brought into our country instead of Mibla go arbitrate outside. Also, Singapore or Natla Place, you may come inside our country, believe me now. Today in our country, Mr. Acting Speaker, you may got the 4 big global super conglomerates in our country as we speak. The 2 leading companies in oil and gas, namely ExxonMobil and Total in our country. The 2 leading mining companies, namely Newmont and Barrick in our country. They are consolidating their business base in our country. They have trust in our country's law and the legal system, and this bill that we are amending may seem small, but it also adds value to our credibility as a good, safe, secure investment destination. Any disputes that we may have in our country can be arbitrated, and this one now gives rise to a modern arbitration platform that investors outside and far and wide can look in and say PNG has arrived at the stage where the judiciary is sound, judiciary secure, the arbitration process is also upgraded, secured, and modernized, that is United Nations sanctioned and based. I want to ask all members of Parliament, thank you for support. It may seem small, but an important contribution to modernizing our ambience of our law and justice sector system. Thank you, Mr. Speaker.
The question is that the question be put. Those in favor say aye. Aye. Those against say no. Ayes have it. The question is that the bill be now read the 3rd time. In accordance with constitutional requirements, this bill must be passed by an absolute majority of 60 members. Clerk, ring the bell. Attendants, close the door. The question is that the bill now be read at a time. Would those in favor please stand? Would those who are against please stand? Honorable members, for those who vote in favor of the bill, 91, and noes, nil. Clerk.
Third reading, a bill for an act to A, recognize and give effect to the agreement of contracting parties in domestic commercial agreements and other domestic agreements or any other domestic matter amendable for resolution by arbitration. B, to repeal and replace the Arbitration Act, Chapter 46, with respect to domestic arbitration. C, to promote use of modern forms of arbitration as a means of alternate dispute resolution and for related purposes.
Clerk.
Order of the day number 85, Minister for Justice and Attorney General.
Minister for Justice and Attorney General.
Thank you, Mr. Speaker. I present the Arbitration International Bill 2023.
Clerk.
First reading, a bill for an act to present, a bill for an act A, to recognize and give effect to the agreement of contracting parties in international commercial agreements to resolve their disputes by arbitration, and B, to give effect to a domestic law to the United Nations Convention on the recognition and enforcement of foreign arbitral awards 1958, New York Convention, and related instruments and for related purposes.
Minister for Justice and Attorney General.
Mr. Speaker, thank you. I move that the bill is now read the second time.
Minister, make your speech.
Thank you, Mr. Speaker, for giving me the opportunity to present to this Honourable House and the people of Papua New Guinea this important bill to provide comprehensive framework for international arbitration. Mr. Speaker, arbitration is a dispute settlement mechanism that is a complete alternative to ordinary litigation. It is both consensual and private in nature, and operation resting largely on party autonomy, whereby parties can enjoy a very substantial amount of freedom in laying down their preferred rules to resolve an arbitrational dispute. The freedom is guaranteed to physical and legal persons, but formal law arbitration operates more meaningfully through state-sanctioned enforcement, whereby national courts are prepared to enforce arbitration agreements and to land and domestic law must also be prepared to assist where party autonomy proves insufficient, such as when the process of appointing arbitrators breaks down. Arbitration must therefore always take into account the existence of national legal systems and the limits or interference that may derive from them. Mr. Speaker, Papua New Guinea acceded to the Convention on the Recognition and Reinforcement of Foreign Arbitral Awards, New York Convention, in 2019, which now enables PNG to domesticate the arbitration rules of the United Nations Commission on International Trade Law. On 20 September 2023, through decision number 263/2023, NEC approved the drafting of the arbitration bills. Mr. Speaker, the law governing arbitration in PNG is the Arbitration Act 1951. This free independence law in its current form is not conducive and compatible to cater to both domestic and international arbitration in PNG. It is not consistent with international best practices which have developed through international instruments such as the New York Convention and unilateral model law, which has come to be adopted by many jurisdictions. Having acceded to the New York Convention in 2019, it is only appropriate for PNG to now reform its existing law to provide an up-to-date framework for both domestic and international arbitration. A dualist approach is taken on PNG's reformed legal which will deal with domestic arbitration, whilst the proposed international arbitration bill shall deal specifically with international commercial arbitration. Arbitration International Bill 2023. Mr. Speaker, international arbitration is widely regarded as the preferred means of resolving commercial and other disputes throughout the world. Commercial parties are attracted to international arbitration for the speedy expertise, confidentiality, and neutrality of arbitral process, as well as the worldwide enforceability of foreign arbitral awards. Enacting international arbitration reform can attract foreign investment to PNG by providing assurance of a stable and predictable legal environment to foreign investors. Mr. Speaker, the scope of arbitration. Mr. Speaker, the scope of the bill is intended to cover international arbitration and also establishes PNG as a potential seat of arbitration. The intention is to provide a framework in which procedural rules chosen by parties to govern the arbitration can operate and may fill gaps not addressed in the rules. Mr. Speaker, the features of the Arbitration International Bill 2023. Mr. Speaker, that the following are the salient features of the bill. It gives effect to PNG's obligations under the New York Convention and incorporates substantially the unilateral model law. 2, establishes PNG as a potential seat of arbitration. 3, establishes the recognition and reinforcement of arbitration arrangements. 4, enables the recognition and the enforcement of foreign awards in PNG. 5, emphasizes the importance of arbitration agreements by laying down the formal requirements for the agreement, particularly that it may be in written form. 6, recognizes the autonomy of parties to shape the arbitral processes. 7, provides for default rules regarding the arbitral process. Mr. Speaker, the purpose of the Arbitration International Bill 2023. Mr. Speaker, the purpose of the bill is to, 1, make provision for the conduct of international arbitration. 2, encourage and facilitate the use of arbitration as a method of resolving disputes using international arbitration. 3, facilitate the recognition and enforcement of arbitration agreements and awards. 4, give effect to United Nations Convention on the recognition of enforcement of foreign arbitral awards 1958. Mr. Speaker, finally, I would like to acknowledge the judiciary for recognizing the significance of this important reform and leading the work for the development of this bill together with the Arbitration Domestic Bill 2023. I would like to also acknowledge the contribution of all who have assisted with the accession process to New York Convention and drafting of the bills. I thank you all the efforts put in to come this far. With that, Mr. Speaker, I commend the Arbitration International Bill 2023 to this Honorable House. Thank you.
The question is that the question be put. Those in favor say aye. Aye. Those against say no. Ayes have it. The question is that the bill be now read the second time. Those in favor say aye. Aye. And those against say no. Ayes have it. Clerk.
Second reading. A bill for an act aid to recognize and give effect to agreement of contracting parties in international commercial agreements to resolve their disputes by arbitration, and B, to give effect in domestic law to to the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958, New York Convention and related instruments, and for related purposes.
Minister for Justice and Attorney General.
Thank you, Mr. Speaker. I ask leave of Parliament to move the third reading forthwith.
Is leave granted? Minister for Justice and Attorney General.
Thank you, Mr. Speaker. I move that the bill be now read a third time.
The question is that the question be put. Those in favor say aye. Those against say no. Ayes have it. The question is that the bill now be read the third time. In accordance with the constitutional requirement, this bill must be passed by an absolute majority of 60 members. Clerk, ring the bell. Attendants, close the door. The question is that the bill now be read a third time. Those in favor, stand. Those against, please stand. The Honorable Minister for Housing, I will ask you to resume your seat until I announce the result of the vote. Honorable members, those who vote in support of the bill, 88. Those against, nil. Clerk.
Third reading. A bill for an act A, to recognize and give effect to the agreements of contracting parties in international commercial agreements to resolve their disputes by arbitration, and B, to give effect to domestic law to the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards 1958, New York Convention, and related instruments, and for related purposes.
Thank you, Minister. Clerk.
Notice number 88, Minister for Environment, Conservation and Climate Change.
Minister for Environment and Conservation, Climate Change.
Mr. Speaker, I present the Protected Areas Bill 2024.
Clerk.
First reading, a bill for an act to manage the Protected Areas Network, Protected Areas and Protected Areas Policy, and B, to conserve and plenish the biodiversity of the environment, plant and animal life, and 2, land and its scarce scenic and historical qualities in Papua New Guinea for the benefit of ourselves and future generations, and C, to conserve the natural environment and cultural heritage subject to any zoning, declaration or registration of a protected area, and D, to repeal the Conservation Areas Act, Chapter 362, and Fauna Protection and Control, Chapter 154, and for related purposes.
Minister for Environment Conservation.
Mr. Speaker, I ask leave of the Parliament to move the second reading forthwith.
Is leave granted? Minister for Environment and Conservation.
Mr. Speaker, I move that the bill be now be read a second time.
Make your speech, Minister.
Second reading speech on the Protected Areas Bill 2023. Mr. Speaker, the Protected Areas Bill 2023 aims to implement PNG's biodiversity conservation strategy. The PNG National Policy for Protected Areas 2014 provided the terms of reference for the framework of this bill. Using this framework, the bill was formulated in collaboration and consultations with stakeholders through an extensive process, including 4 regional meetings. Formal submissions were provided to SEPA by Chamber of Mines and Petroleum, PNG Forest Authority, Department of National Planning and Monitoring, Department of Treasury, from donors such as JICA and NGOs such as Fawcett, based in Eastern Britain, and a number of informal discussions have been undertaken. A number of national policies support the development of this bill, including the explicit commitment to environmental sustainability contained in the Vision 2050, the PNG Development Strategic Plan 2010 to 2030, and the National Strategy for Responsible Sustainable Development for PNG, and lately the Medium-Term Development Plan 3 and now 4. Mr. Speaker, in discharge of PNG's international law obligations under the United Nations Convention on Biodiversity, UNCBD, to achieve a target of 17% area of land and 10% marine as protected areas by 2020. And in discharge of its mandate from the NEC, in Decision 325/2014, SEPA has consulted widely with the communities doing protected areas in all regions during 2016, and with affected government officers, agencies and departments. In lengthy dialogue, the bill has taken into account community input from these dialogues. Mr. Speaker, the bill follows closely the structure, text and spirit of the NEC-approved Papua New Guinea policy on protected area 2014. The bill now before the Parliament balances constitutional authority shared between the national, provincial and local level governments under the Organic Law on Provincial and Local Level Government, with the reality of the customary ownership of much of the land in PNG and ownership rights to achieve a workable framework for conservation and protected areas. It addresses issues of customary landowner marginalization through access of justice mechanisms. Mr. Speaker, the bill provides mechanisms to allow the national government, through its lead agency, the SEPA, to engage with the provincial and local level governments who share lawmaking powers with parks, etc., and local government under the organic law on provincial and local level government. Similarly, the bill provides mechanisms for SEPA to contract directly with customary landowners, some of who, through the ILG process, will in future hold freehold title, while others hold on to custom, on terms with the agreed, as part of the negotiated process to be achieved with full, free, prior, informed consent, and landowners represented by lawyers of their choice. Mr. Speaker, the bill includes dispute resolution mechanisms, a model that favors cooperation in conservation and protected area business, binding agreement with other affected government bodies to ensure uniformity of overall policy, planning, implementation to clarify management processes with government and non-government bodies or persons to our disputes, mediation and arbitration as the preferred models of dispute resolutions, and access to courts for the persons aggrieved. Mr. Speaker, the work within SEPA has been facilitated under the Global Environment Fund, part of the PNG's term of the CBD, administered in the country through the United Nations Development Program. This is an ongoing process delivering institutional stability, conformity with international obligations, standard, and the likelihood of long-term support, including the seeding of the Biodiversity Fund when developed in a later date. Mr. Speaker, the Protected Areas Bill 2023 went through the CACC waiting process after the CACC endorsed the Protected Areas Bill to go to the NEC. The NEC endorsed the drafting instructed for the PA bill in the decision 39 of 2022. The FLC Council has finalized the bill which I present to you today, Mr. Speaker. I would therefore appreciate the support of the honourable members of this House for this important bill. I commend the Protected Areas Bill 2023 to this honourable House. Thank you.
The question is that question be put. Those in favour say aye. Those in against say no. Ayes have it. Mr. Clerk. The question is that the question be now put. Those in favour. The question is that the bill be now read the second time. Those in favour say aye. Aye. Those in no. Those in against say no. The ayes have it. Clerk.
Second reading. A bill for Act to A. Bill for Act A to manage the protected area, protected areas, and protected area policy. B. To conserve and replenish the biodiversity of 1. The environment, plant and animal life, and 2. Land and its sets, scenic and historical qualities in Papua New Guinea for the benefit of ourselves and future generations, and C. To conserve the natural environment and cultural heritage subject to any zoning, declaration or registration of a protected area, and D. To repeal the Conservation Areas Act, Chapters 362, and Fauna Protection and Control, Chapter 154, and for related purposes.
Minister for Forest, Minister for Environment and Conservation.
Mr. Speaker, I ask leave of the Parliament to move the third reading forthwith.
Is leave granted? Mr. Speaker, Mr. Minister. Is leave granted? Mr. Minister.
Mr. Speaker, I move that the bill be now read at a time.
Governor for Northern Province.
Mr. Speaker, I wish to debate this bill.
Go ahead.
Thank you very much. A very important subject that sometimes we tend to overlook because we're all very eager to develop our country and, liquidate all our natural resources and make significant profits for multinational companies and forget the very fact that it's this environment that ensures we survive and thrive now and on into the future. I want to thank the Minister, and I commend him. This bill has been in the pipelines for so long. NGOs and various concerned persons have been contacting me every time there's a parliament session asking me when this bill is going to be tabled. So, Minister, thank you very much for bringing this bill to the House. I just have a few points to make. But before I make those points, I want to quote a very important statement made by the Secretary General of the United Nations in New York in July 2023, where he coined the term global boiling to replace what we have known as global warming. Because of the severity of the situation facing humanity, mankind. You'll note that it has been getting hotter everywhere. Everywhere you go, the nights are hotter. Even in the mountain areas where it is traditionally cool and misty, there are heat waves. Rising sea levels are depleting our beaches and coastal shores. Some of our atolls are now uninhabitable. People cannot live on these atolls anymore. The Carteret Islands is a classic example. The first climate change refugees in the world. We are now having to transport them onto the mainland because they cannot live there anymore. But we are still marching on, ignoring all these realities and depleting our natural resources as if there is no tomorrow. And fine, we should be able to make way for the growth of our populations, the spread of mankind, humanity, and whatnot, but we should also take stock of what is happening that threatens our very future. Today, geologists term the age that we are living in as the Anthropocene age, the age where man's activities affect nature. Whereas in the past it was nature's activities affected mankind and how we lived. Today it's the other way around. And we are very irresponsible in how we are behaving. The world is recording the hottest months ever recorded in the history since humanity existed. It's very frightening. This natural environment is what protects us a forest people, Papua New Guineans. 7% of the world's biodiversity is in this country, on this island. It is the third largest rainforest in the world. But what are we doing to protect this? These rainforests are biostations. They produce air, they cleanse water systems, and they house biodiversity that contribute to life on Earth. And organizations like SIPA and others are charged with the responsibility of protecting this environment. These structures that ensure that we survive and thrive. But I can tell you that these organizations are not functioning as they ought to. We are going to pass more laws again, and so forth into the future, we will no doubt be passing more laws, but are these laws being enforced? I ask members to go to your local districts, your provinces. Take a walk to wherever there is some development taking place by some company. And in many instances, they're doing so at will and whim without abiding by these very laws that we are passing here. What's the point of passing laws if we cannot enforce them? In my province, we have taken a number of court cases against logging companies, for example. We just won one recently in an area called Ifane on behalf of the landowners because a company had been encroaching in that area. They'd been logging in the incline areas and the waterways. You're not supposed to be logging in these areas, but yet they were doing so. And no one turned up to check on them, even though reports after reports were submitted by landowners, the provincial government, concerned community members. And this is the case all around the country. And it's not just logging companies, but other activities that are undertaken by various individuals or companies. Yes, we want development, but they must abide by our laws. And the organizations charged with enforcing and administering these laws have to do their job. That's why they're called authorities. They are authorized to do these jobs. They're authorized to enforce the law, administrate the law. But they're not doing this. Many of them have become mercenary entities just there for the purposes of procuring a permit or a license for whoever turns up with a bag of money. This is the reality we are facing now. And the people of this country deserve to be protected. Their future, the future generations, they deserve to be protected. But they are not getting the protection. And we are very enthusiastic about developing our natural resources, but it should not come at the greater cost to our future generations, where they are not afforded the natural environment that we are fortunate to take for granted today. I commend the minister. He has done a magnificent job since he took up that ministry. Every time I ask him of questions, he has always ensured that he has prepared his answers, he has turned up, he has delivered. But more needs to be done, and we need to assist our minister. And this is where I feel that we have to take a very serious look at who we are appointing to head these organizations. We must appoint fearless, patriotic Papua New Guineans who are not timid, or who are not going to sell out, or who are not weak, or who are not easily bribed or influenced or induced by foreign companies or multinational companies or even Papua New Guinean citizens. They have to protect Papua New Guinea 247, 365 all the time. They swore an oath to serve without fear or favor. They have to do that explicitly. They have to protect the interests of this country jealously. That's not happening. So many of these organizations are not performing their duties, and ministers, you preside over these ministries. You have to take a walk through these organizations and find out what they're actually doing. They're going to con you. They'll buy you a VX and a ticket to go to Singapore and around, I'll buy you listing thing, I'll walk through blow you. You'll think everything is okay. Everything is not okay. So while I commend the minister, I just want to say that there's a lot of work that needs to be done so that your organization can fulfill its role and responsibilities to the people of Papua New Guinea by actually getting out there and conducting audits and inspections. There are not enough of those taking place. They're constantly holding workshops and forums. This is a favorite activity of our public servants. A lot of the budget of ministries, departments, statutory organizations are taken up in workshops and forums. Hire cars, travel allowance, hotels, overseas conferences, to do what? They should be out there inspecting. They should be out there auditing. They should be keeping an eye on the developers of this country. Those who are coming to this country to develop this country, whether they are abiding by our laws or not. And they should find them. They should not hesitate to find them. They should not hesitate to hold them accountable. The ordinary village person in this country cannot afford a lawyer. These people have lawyers at will and whim that they can send to court, and they tie up cases in court for days, weeks, months, years. We have a classic case in Waningela, where while we were in court, ships were still shipping out logs on a monthly basis. And we went to court, they took out a court order. Here's another thing that we don't like to criticize the courts, but sometimes they need to take note of these things and they need to hasten the decision making. Because while they're taking their time and deliberating over whether this is right or wrong or legitimate or not, a lot of these activities are still going. The trees are still being cut, the holes are still being dug, the ships are still sailing out, the best are still being caught and illegally shipped out. And where are those who are supposed to protect this country, the guardians of this nation, the guard dogs? Hey, almost stop loud slowly, all run, whatever. Selling this country is what they're doing. So I urge you, ministers, you need to take stock of what is happening in your ministries, in your departments. So I'm not being critical of you. I'm encouraging you to make an effort to take a walk through your government departments and find out, do an assessment of your CEOs. Many of our CEOs, they are not vigilant. They're not patriotic. And they are busy following you around, Minister, when they should be managing their departments, when they should be ensuring that their departments are enforcing the laws to protect this country and its citizens. SIPA is one of the most, unfortunately, toothless organizations in this country, in a long list of toothless organizations. We need to empower them so that they get out there and do their work. And here's one for Treasury. When these government departments come to you with their budget, there's a very important line item for enforcement, investigations, and prosecutions. For some reason, Treasury always cancels these areas. And they never get the funds that they require to go out there and carry out these activities. So that's one area that really needs to be seriously looked at. If we want these organizations to function, we need to empower them by funding them so that they can function. And another thing, we need to allow them so that they can be self-funding. They can retain a percentage of the revenues they raise through fines and penalties that they impose, or the permits that they are, and licenses that they issue. More than 90% of our people live in the rural areas. They depend on our natural environment. They depend on the forests. They depend on our land, our fertile land that we take for granted. They depend on our oceans, our lakes, our rivers. And we need to protect this so that it can protect them and they can continue to live a decent, normal life and give that type of life to their children and future generations. And it's up to us to make that happen. If we don't do that, then we are failing not only our people of today, but our children of tomorrow. Thank you.
Leader for Opposition.
Thank you, Mr. Speaker. Assistant Speaker, me too, me like joining Parliament to debate on this very issue, Mr. Speaker. I'll be very short. Now, suppose me pull him talk, you can stop me. Mr. Speaker, this bill, it's a very, very important bill. A bill, like Governor Oro has mentioned, has taken a long time to come to this House. But it has come at a time where I think we are ready to take this bill through. Now, Mr. Speaker, two things. Number one, the population of Papua New Guinea is not shrinking. It's actually growing at a very fast pace. And this year, when the census comes through, we'll actually know whether we have 9 million people or 13 million people. Now, with the increase of population in our country, Mr. Speaker, all man before, back in the 70s and 80s, if you were born in the 70s and 80s, you'd realize that some place where all man, stop. Now all man go sit down on top of this place. Place where all sak stop, where all man katim na produce kai blow. And all man katim slow sak, no man sit down on top of this ground to this. Because groundwork was soft. So population in our country is becoming a problem. Country blame you may look at some plant the ground before, and will shrink too. So good for something or some Minister, you have brought forward a bill that will protect certain areas, identified areas in our country, where we should regard as taboo areas and not touch. Mr. Speaker, the other area of concern that I should speak about with regards to this bill is, Mr. Speaker, the fast development that is encroaching into areas that were once never touched. Roads being constructed, Mr. Speaker, wharfs being constructed, and passages being constructed so that ships can come in. And you look at the corals and the reefs that have been destroyed in the pretext of development. Plenty all areas where all put in more log ponds. Plenty areas all put in more some passage by go inside the place. Mr. Speaker, has destroyed some of the corals and reefs and habitat of marine resources that cannot be replaced anymore, that are irreplaceable. Now this bill today, I personally think that will help us in developing certain departments for that matter to take into consideration these important areas that needs conservation and protection. Mr. Speaker, I take note of road constructions in our country. Road constructions that are going through areas where there is greater biodiversity, areas that were once protected so that people can go and hunt. People can go and cut materials for their houses, are now being destroyed with the name of development, road construction, so and so. And so, Mr. Speaker, I'd like to, I'm happy that Minister for Works is here in this debate, and maybe he can take note so as the Prime Minister and other ministers. In the term of road construction, or definition of road construction, when we put the road through a virgin forest, number one, a pre-survey needs to be conducted. A pre-survey needs to be conducted so that you establish where this flora and fauna is. And if you have to design the roads so that the roads go around that protected area, it should happen. Plenty time you may talk, oh no, this area I'm stopped now, suppose you may put him road around him and by go long plat to us. We have to cut out that nonsense and look at the protection of these areas. Number two, area that I think we should also be looking at, Mr. Assistant Speaker, is the historic areas. Some 40,000 years ago, the first Papua New Guineans landed in Papua New Guinea. All that area where all been stopped past time. All been losing our clay pots blow. All been losing some building materials blow. It's stopped this area yet. Now plenty of white man in Sakolimo or tourist. Sakamlo country blame me. Because we are one of the last nations in the world that still has historic significance in our country. Now like come now looking. That's what time will come. Development come and I'm destroying these little areas. I'll give you a very good example, Mr. Assistant Speaker. A few years ago, we got the road construction on the island of Kirwina. And as they were building the road, they came, the bulldozer accidentally cut through a corner, and they were inside that a cave that was discovered were old clay pots inside. Stone axes inside. And they had to stop, come down and get the administration to go and have a look at it. And we had to somehow protect that area because some people have already gone in to get some of these things out. Now these are history that are sitting down in this country, and we need to protect those areas. Now thank you also, Mr. Speaker. The Minister, in his wisdom, has brought forward a paper to us, significantly important paper for us to take into consideration. Let me finish by saying this, Mr. Assistant Speaker. It's not far from Port Moresby, this Parliament House. You just have to drive down to Motukea area, towards the Porabara area and those areas. And you find out that the mangroves there are all totally destroyed.
Where is the bill? Where is the protection that we have here in this country that should conserve those areas instead of destroying them in the name of development? High waves come, they wash right through because we've removed the protection that nature has provided for us. Our reefs in Oklahoma destroy them now. They are nature's protection for mankind. And you may destroy him go. Also, Mr. Speaker, you don't have to look far to see developments that are happening, whether it's a development law all aspects or development law national level. We need to somehow legislate to protect our biodiversity, believe me. And I do agree with Plantioman Toktoko, 7% of the flora and fauna in the world is found here. You may see 7% to be very small, but I tell you, it is significant. Thank you, Mr. Assistant Speaker, for allowing me to talk. Thank you, Mr. Speaker.
Minister for Petroleum.
Thank you, Assistant Speaker, on giving me space to join the debate.
Mining.
We got a couple of points to say. Firstly, I would like to commend the Minister for Environment, Conservation and Climate Change for bringing this very important bill to this House, which has been pending for a very long time because of some of the very critical issues that were raised by NGOs, environmental advocates and the industry. But I commend your leadership and your ministry to resolve all these issues and finally bring to this floor the final bill to be passed. We have many conservation laws that governs environment conservation in this country, the Conservation Areas Act, the Flora and Fauna Act, and also our country signs up to many international environmental conventions and also regional conventions that has targets insofar as regional targets and our national targets are concerned. All countries in the region have their individual targets. But for our country, for terrestrial landmass conservation, we must conserve 17 to 20% of our terrestrial landmass by 2030, and at least 10% of the marine environment by 2030 also. But our performance so far has been dismal. We have not performed to match other countries in the region to really put a strong focus on conservation efforts in this country. So far, we have conserved 3 to 5% of our terrestrial landmass. You see all this breakdown and rundown of protected areas in the country. We, in the past, in the 1970s, we had many conservation areas in this country. But now they've been run down. Rangers have no jobs. Locals are not able to sell their produce and sustain themselves. And there's no visitors. Those protected areas have run down because we are not able to sufficiently fund those conservation areas. And this bill will really improve our efforts in this space because it wants to address those challenges in a coordinated fashion. It will ensure that we have an effective network of protected areas in this country, and that has to be effective coordination between landowners, provincial governments, and the government as a whole, and with sufficient funding to be provided for by the government, NGOs, so that we can be able to finance those protected areas in the country. Likewise, in the marine space, we were supposed to conserve 10% of our marine environment within the 12 nautical miles within the EEZ. But we are not able to conserve. Our performances have been dismal. We have conserved at least less than 1%. So this bill provides for the legal framework for us to empower all stakeholders involved. And I also note that there's a provision for establishment of a biodiversity trust fund. One of the key reasons why we don't advance conservation efforts in this country because government continues to fund 1 million, 5 million, less than 10 million every year
And with all the competing interests in the oil and gas, mining and forestry sector, the landowners cannot give away. So that's why this bill paves way for this, and the provision of the Biodiversity Trust Fund is very important. Minister, I encourage you to bring the Biodiversity Trust Fund legislation or regulation into this floor. So we must legislate for sustainable financing of protected areas in this country. We must raise revenue in the energy sector, the mining sector, forestry, all sectors. At least they must pay some form of levy into the Biodiversity Trust Fund. So we must be able to conserve our marine environment as well as the terrestrial environment and meet those targets and even advance that further, because that's very important for our future generations. We can't continue to exploit and plunder the natural resources because they are the sustenance of our life. We must maintain quality forests, we must maintain quality water systems, and we must maintain quality biodiversity in this country, because if we don't, we will not be able to, it will really affect the sustenance of our life. And we must also note that while we talk about oil and gas, forestry, and all other resources in this country, biodiversity and the tropical rainforest that we have that produces tons and tons of fresh air is a global public good. And it will come a time when we will commercialize those services that those biodiversity provide. And you will see that the monetary value of the services that we provide in this country, our environment, our biodiversity provides is very, very huge. So, Minister, with that, I'm very glad to see you mention the biodiversity. Please bring in the Biodiversity Trust Fund legislation, and I encourage the House for us to legislate levies to be collected in all sectors, because we must be able to substantially finance protected areas network in this country, including our marine protected areas. Thank you, Mr. Speaker.
Member for Abau.
Thank you, Mr. Speaker. I'll be very short, but I want to take the cue from those who have spoken before, and particularly the Honorable Minister for Mining, who has expressed excellently the issues that the country needs to sort out, and thank the Minister and the work that you have done, and congratulate you. There's one issue that I'd like to highlight, and that is the outstanding matter of sorting out the customary land issues in the country. While this important legislation is critical, I think the issues mentioned in the minister's statement with regards to recognition of customary landowners in the country and the processes that are prescribed or will be determined, the frameworks that will be determined later, must protect the customary landowners. But I must say that we don't have the customary land legislation at the moment. And so to me, that is an outstanding matter, and it will truly complement our minister's effort. So the two must come hand in hand. Because if you look at the land issues in the country, the arbitration processes are so long, it takes many, many years to solve land issues. And so I strongly recommend, and I'm glad that our Deputy Prime Minister, who is the Minister for Lands, is also taking the lead on this. So I strongly recommend that the two agencies of state complement each other. There's one area that the Minister has mentioned in his statement, talked about the ILG process, and I understand the Deputy Prime Minister and the Minister for Lands and Fiscal Planning, I think, publicly announced review of the ILG process, and I think it's announced that the ILG process must be stopped and we move into a new formalization like clans. ILG is a foreign concept, but clans must be recognized. So, and also in the under the recognition of what the organic law and provincial governments and local level governments, we've been arguing about the role that district development authorities must also play in the process, rather than just the local level governments. And so I think there are a few areas to be sorted out. Minister, excellent job, and thank you very much for the good work that you have done. but I strongly recommend in this debate that the customary land issues be also picked up so that we can complement this important development program. I come from a coastal village. There's a little bay there. 50 years ago, while I was 20 years old, I could throw a stone to the other side of the bank. Today I can't. It just falls in the middle of the river because the river has widened and sea level has risen. And 2 weeks ago, when the high tide came, the high tide hit the floors of the houses for the first time. And so the issues are real. I know this is a global concern, but as one country in the world which can promote preservation, green energy, and all these things, and the technology is now available, I really think that we have an opportunity to showcase in the world that we are pro-conservation. We don't want to cut down our forests. We want to preserve them, and that we want to make sure that we contribute in protecting the world from a boiling state. Thank you, Assistant Speaker.
Question is that the question be put. Those in favor say aye. Aye. Those against say no. Ayes have it. The question is that the bill be now read at third time. In accordance with this constitutional requirement, the bill must be passed by an absolute majority of 60 members. Clerk, please ring the bell. Attendants, please close the door. The question is that the bill be now read a third time. Would those in favor please stand? Those against, stand. Honorable members, those in vote for floor is 82, noes 0. Clerk.
Third reading. A bill for an act A, to manage the protected area network, protected areas and protected area policy, and B, to conserve and replenish the biodiversity of one, the environment, plant and animal life, and B, land its sacred, scenic and historical qualities in Papua New Guinea for the benefit of ourselves and future generations, and C, to conserve the natural environment and cultural heritage subject to any zoning, declaration or registration of a protected area, and D, to repeal the Conservation Areas Act Chapter 362 and Fauna Protection and Control Chapter 154 and for other related purposes.
Thank you, Minister. Clerk.
Notice number 89, Minister for Public Service.
Minister for Public Service.
Mr. Speaker, I present the
regulatory statutory authorities, certain offices, Amendment Bill 2024.
Clerk.
A bill for an act to amend the regulatory statutory authorities, appointment to certain offices, Act 2004, and for related purposes.
Minister for Public Service.
Mr. Acting Speaker, I ask leave for Parliament to move the second reading forthwith.
Is leave granted? Minister for Public Service.
Mr. Speaker, Mr. Acting Speaker, I move that the bill be now read a second time.
Minister, make your speech.
Thank you, Mr. Mr. Acting Speaker. Firstly, I'd like to take this time to convey my sincere condolences to the late Minister for Education, Honorable Jimmy Guru, and the people of Shinabundi and Madang Province on behalf of my people of Nuku. The Department of Special Management, sorry, Mr. Acting Speaker, the Regulatory Statutory Authorities Act 2004, known as the RSA Act, establishes the appointment process for agency heads whose appointments are made subject to the RSA Act. In 2013, amendments were made to the RSA Act to provide a basis for the reappointment process for agency heads, which was further expanded to the RSA Regulation 2014. However, these amendments were annulled by the Supreme Court case of Kereme versus O'Neill of 2019, filed as PGSC7, CG1781 for non-compliance of procedures under Section 14 of the Constitution. Mr. Acting Speaker, due to the silence in the RSA Act and the annulment of the regulation, the reappointment process for RSA Acts heads follows the contract renewal process in the contract of employment, which requires the reappointment to be started 3 months prior to the expiry of the initial contract term. Mr. Acting Speaker, the issue at hand concerns reappointments that are completed after the lapse of the initial contract term. The process under the contract provides that the reappointment must be conducted no later than 3 months prior to the expiry of the contract period. However, the clauses do not clearly state the time frame within which a reappointment must be completed. Therefore, when the contract lapses, there is no basis for a reappointment, and this creates an issue with the reappointment of agency heads that fall within the category under the RSA Act. Mr. Acting Speaker, the Department of Special Management is the department responsible for facilitating contract of employments for the respective heads of statutory authorities. The reappointment process is commenced within the initial contract term as required by the contract renewal process in the contract of employment. However, the NEC decisions recommending the reappointments were done after the initial contract term had lapsed. The proposed amendment to the RSA Act will incorporate a clarifying provision that will state that a reappointment is valid if the reappointment process is completed
after the lapse of the initial term, as long as the performance assessment was commenced within the initial contract term of the agency head. The rationale for the proposed amendments was to ensure that the National Executive Council's appointments are protected and the process is complied to protect the state. Mr. Acting Speaker, I am confident this amendment will bring improved management and leadership by agency heads of statutory authorities. Therefore, on behalf of the Marapero government, I commend the passing of this bill. Thank you, Mr. Acting Speaker.
The question is that the question be put. Those in favor say aye. Those against say no. Ayes have it. The question is that the question is that the bill now be read the second time. Those in favor say aye, and those against say no. Ayes have it. Clerk.
Second reading, a bill for an act to amend the regulatory statutory authorities, appointment to certain offices, Act 2004, and for related purposes.
Minister for Public Service.
Mr. Speaker, I ask leave of the Parliament to move the third reading forthwith.
Is leave granted? Minister of Public Service.
Mr. Speaker, I move that the bill be now read a third time.
The question is that the question be put. Those in favor say aye. Those against say no. Ayes have it. The question is that the bill now be read a third time. Those in favor say aye. And those against say no. Clerk.
Third reading, a bill for an act to amend the regulatory statutory authorities, appointment to certain offices, Act 2004, correction, and for related purposes.
Thank you, Minister. Leader of Government Business.
I thank you, Mr. Acting Speaker. I thank the government side and the opposition side for helping us pass these bills. These bills are pertinent to making the future of our country great. So thank you very much for all the members in the House. Mr. Acting Speaker, I move that the Parliament do now adjourn until tomorrow, 10 a.m.
The question is that the motion be agreed to. Those in favor say aye. And those against say no. Ayes have it. I now adjourn Parliament to tomorrow, 10 o'clock a.m.